First of all, I'd like to remind everybody that this is a public hearing that's being held in compliance with the Freedom of Information Act, and that notice was posted in accordance with the called meeting procedures. Local media sources were timely notified as well. This is a public hearing held by the South Carolina Ethics Reform Commission. We are here in the Brown Building in Columbia, and we have some people who have signed up to speak. If anyone here has not signed up to speak, please do so. Or if you determine that during the course of these conversations or presentations that you want to speak, just say so, because we'd like to hear from everyone. I'd like to welcome all the commission members. General Travis Medlock, co-chair. Thank you for being here. Thank all of you for being here. Charles Bierbauer. Ben Haygood is not present tonight. Flynn Harrell is here. Kelly Jackson is here. Monica Key is not present with us tonight. Bill Rogers is here. John Simmons is here. Xavier Starks is here. Susie McWilliams is here. And also we have Professor Simpkins, who's here. And we're delighted to have you, and we look forward to your legal advice and guidance. We have a number of subcommittees, as you know, and I'll just recite these for the interest of those who are in the room tonight. The Freedom of Information Act and Open Records Subcommittee is chaired by Charles Bierbauer, and also has as members Bill Rogers and Monica Key. The Ethics, Conflicts of Interest, and Campaign Disclosure Subcommittee is chaired by Susie McWilliams, and it also has as members Ben Haygood and Flynn Harrell. Where'd Flynn go? There's Flynn. The Ethics Committee is chaired by John Simmons to my right, and has as members Xavier Starks and Kelly Jackson. The Legislative Initiatives and Liaison with the General Assembly consists of General Travis Medlock and I, and again we are delighted to have Professor John Simpkins with us, who's been appointed as the Commission's legal expert for these proceedings. The purpose of this reform commission is to make suggestions to the governor and the General Assembly by January 28th in written form. And we want you to be comfortable here. We're delighted you're here. We're looking for information and ideas from any source. Please feel free to call the commission members if you want to send messages. This is a very open kind of a proceeding. We're not going to stand too much on formality, although we do ask people to watch the clock with us, and at your first chance at the microphone, please try to stick to 5 minutes, and we can come back to you when the others have had a chance. And we have plenty of time. We don't have to leave here till 8 o'clock tonight. So we think everybody will have plenty of time to talk. We want to produce a good product for the people of this state. The governor, the General Assembly, there are many parts of the state government as well as private organizations that are deeply interested in seeing that we have good, solid ethics reform. There's no doubt that we, like every other state in the country, need it. So we're hoping to begin that process by this commission. We've already begun, but we hope to begin the public part with you tonight. For your information, the future meetings will be on Monday, December the 10th. We'll have a public hearing again before the full commission, and we may need to hold another meeting as well. On Tuesday, December the 11th, we will have a testimonial hearing to receive testimony and written recommendations from various organizations. I referred to some of them a little while ago. Also, on Tuesday, January the 8th, we will have a full commission meeting to consolidate written recommendations from the various subcommittees and to discuss final recommendations. On Tuesday, January the 22nd, we will receive final written report and recommendations and discussions. And on Monday, January the 28th, we will provide a written report to the governor and members of the General Assembly and the public of our conclusions and recommendations. And we hope that they will be comprehensive and that they will be good. I can assure you that everybody here has spent a lot of time already. There are some of the subcommittees who've met. There's been a lot of conversation. And again, our purpose is to encourage conversation. We have a number of people who have signed to speak. General Medlock, would you have anything for us before we begin that process?
Well, I think we can go forward.
All right. With that, I'd like to call on Willie James Brooke. And as you're coming up, Mr. Brooke, come on up. Are there any members of the commission that have anything they'd like to say to the assembly? Well, just as we get going along, don't feel shy. I know everybody here is used to talking in public. Yes, sir. Go right ahead and make yourself at home. Tell us who you are, where you're from, and then go ahead.
Thank
Please.
you, Mr. McMasters and commissioners and state residents. My name is Willie James Brooks. I'm from Travelers Rest, up near the college at Blue Ridge, Tigerville. So that's a little bit past Travelers Rest. But I was born and raised right here. I saw it in the paper, and I've been hearing about ethics. And I know a few people that had a few concerns for, and I think it's about doing the right thing, or fair treatment. I'm not really sure, but I did had a complaint and a request. My complaint mainly concerns excuse me just a moment, the decision review officer at the Department of Veteran Affairs. And my concern is that while I have a representative, Mr. Clark with the VFW, for the past 10 years I've been trying to file a claim. And this officer, he has leadway where he cannot be challenged. And people pretty much go along with him whether he wants to or not. Mr. Clark is new. It's not fair to him. This has been a cover-up that's been going on for some time. And it's not fair to him to be victimized by others who are covering up or who are going along with the decision review officer. I have documented this information as evidence that was founded by a officer at the hospital at the governor's office. And we sent it to them, and to this day we haven't heard from them.
I'm sorry, you said you sent something to the governor's office?
A Veterans Affairs officer at the hospital in the governor's office found an error that they'd made, and we forwarded it to the Veterans Administration. This is back in February, and they have not responded yet. I've documented these things. Everyone else is, like I said, covering up or going along. I know it's a shame, and I'm not trying to get anybody in trouble. But if it's about ethics, then everyone should be required to do the right thing. I'm an honorable discharged Marines of 2 services. Marines made me what I am. I love the Marines. I'll be 62 in August. I was a sharecropper, Robinson and the McKinneys in that area. So I think I've done good enough. I want to present this complaint and this recommendation, this request for assistance to this commission. I hope that you will accept it.
We'll accept it.
And I thank you kindly.
Thank you. This may be slightly out of our jurisdiction, at least some of it, but we're delighted to have it, and we appreciate you being here. Any questions? Does anyone have any questions for the gentleman? Well, we do want to thank you for your service. Thank you very much.
If you're 62, you're a very young man.
Thank you, Mr. Brooke. We also have James A. Porter. Is Mr. Porter still with us?
Yes, I'm here.
Come forward, please, and speak into the microphone.
I don't know whether I'm in the right meeting here or not. Good evening to everybody here.
Good evening.
I'm James Porter. Live here in Columbia. Spent over 26 years in the military, retired, and been living here in Columbia ever since. But like I said, I don't know whether this is the right meeting, but I knew that there was supposed to be a meeting tonight by the SCE and G. This
This is the wrong meeting.
is the wrong meeting.
And I can tell you where it is if you want to. That's a PSC hearing that
Thank you, Ms. Timberlake. Tell him where it is. You sure you don't have something you want to say about ethics before you go? Come back and see us when you got more time. Professor Lawyer Dr. Bender, you're next on the list. We're glad to have you here.
Mr. Chairman.
Let
members
me
of
ask, is anyone here who wants to speak, who already knows they would like to speak? We have a gentleman in the back, okay. Well, I think because we have plenty of time and not that many people clamoring for the microphone, we might relax the 5-minute rule and hear what you have to say.
Well, you know, in school, we're trained to talk 55 minutes at a minimum, but I'm not going to take that time here. In fact, I've prepared remarks for you, and I'll pass them to Mr. Jackson and ask
Thank
him
you.
to pass them around. I'm here, and for identity, I am the Reed H. Montgomery Freedom of Information Chair in the School of Journalism and Mass Communications at the university, but my remarks are mine and not those of the university. I haven't been in the presence of so many generals in years. This is impressive. My remarks are going to focus on what I believe your task is. And I looked up ethics in my dictionary, and it is the science of morals in human conduct. And in the South Carolina appellate court rules, which apply to me in my law practice and to those of you who are in the practice of law here, these rules do not exhaust the moral and ethical considerations that should inform a lawyer, but simply provide a framework for the ethical practice of law. Now, I teach a course in the journalism school called Law and Ethics in Mass Communication, and I tell my students that law is the mandatory minimum standard of conduct in our society, while ethics is an aspiration. We strive to be ethical. We are required to conduct ourselves lawfully. And I think what you're about here is not ethics reform, but legal reform. And I think that we need to make that point because you need to establish for people who hold positions of authority in our state a standard of conduct that will be enforceable and will be understandable and can be aided, I think, by strengthening portions of the Freedom of Information Act. Your task is not easy. Your way ahead runs counter to some baser instincts of human nature and a long-established South Carolina political culture. Human nature first. Those to whom we have given power believe, in many instances, that they are sacrificing to exercise that power on our behalf. As an example, we once had a circuit judge who, for years before he became a judge, was a member of a state commission, and during his being considered for judgeship, he was criticized for his use of state resources. And he thought that criticism was unfair. As he explained to me one time, he had given the state more than he had taken. If you're in public service, taken is not what you're about. You're in public service to serve. And then there's our political culture. Dr. Walter Edgar outlined it for us in his epic work, South Carolina History. The South Carolina colony was founded by people from Barbados, where a rough and tumble white minority ran an enslaved black majority. And that was our political culture, and I believe that remained our political culture through the Civil War and then was imported directly into the Mill Village. And it wasn't until the mid-1970s that started to change in politics in South Carolina. We have long had a minority of elites that have taken it upon themselves to tell the rest of us what we will like and how we will like it. And it began to change, I think, with single-member district representation in the General Assembly and in other areas, and in 1974 with the enactment of South Carolina's first version of the Freedom of Information Act, led by the Richland County Legislative Delegation, which included co-chairman Travis Medlock. But we didn't change the culture with that, and I'll give you an example. One of the first Freedom of Information Act cases to reach the Supreme Court was Cooper v. Bales. Ellen Cooper was the president of the Richland County Education Association. The Richland School District 1 was considering its annual budget. Ellen thought it would be appropriate for school teachers and members of the public to attend the board meetings to see the discussion on the budget. The school board, led by Joe Bales, thought otherwise, hence the name of the case, Cooper v. Bales. The case was tried with Gene Toll representing the Richland County Education Association. The trial judge was retired Chief Justice Joseph Moss from the South Carolina Supreme Court, who had come out of this political culture that is characterized by an elite telling the rest of us what we will like and when we will like it. He ruled against the teachers and said point blank he could not believe the General Assembly intended for citizens to be able to attend a school board meeting to watch the budget being discussed. When the budget was adopted, that would be soon enough for them to learn about it. And the case was appealed to the Supreme Court, and the 5 justices had come out of that same political culture, and they too found it unbelievable that the General Assembly intended for citizens to watch a budget being developed. So you're swimming upstream here. You still have much work to do in changing this culture. Now, how do you think the Freedom of Information Act relates to this? Here are some examples where I think increased access and a more readily available redress for violations of the Freedom of Information Act will help. And here are some examples. The Lexington-Richland School Board did not disclose records that would have revealed that the owner of property adjacent to the site of a new high school was a business partner of a school board member. The Anderson County Council directed the county administrator to withhold from a council member invoices from attorneys performing legal work for the county, invoices which later revealed that the attorneys were performing personal legal work for the county administrator and creating a political action committee to campaign against the council member who wanted to know how public money was being spent. The company that operates a landfill in Barnwell County planned a closed bus excursion for the House Agriculture Committee to view the site and consider extending the permit for the landfill until the press got wind of the excursion and demanded a seat on the bus. A school board member in Cherokee County arranged for her relatives and her significant other to be employed by the school district and then urged the district to resist requests for access to employment records. The York County Sheriff refused to disclose disciplinary records of deputies who were suspended for conduct unbecoming a deputy based on allegations that the deputies were falsifying investigative reports and stealing recovered property. Why this focus on the Freedom of Information Act? As the South Carolina Appellate Court rules state, compliance with the rules, meaning the rules of practice for lawyers, as with all law in an open society, depends primarily upon understanding and voluntary compliance, secondarily upon reinforcement by peer and public opinion, and finally, when necessary, upon enforcement through disciplinary proceedings. Public scrutiny is an essential ingredient of a successful democracy, and your recommendations for reform should note that South Carolinians need a more effective mechanism to enforce their rights of access, as civil litigation is too slow and too expensive for citizens, and criminal prosecutions are not readily available. And ultimately, it is the public opinion that will reform the culture to make it unacceptable for our elected officials to have secret employment, secret relationships, and an attitude of entitlement. I thank you for the opportunity to be here. I'd be happy to answer any questions you might have.
Thank you. Does anyone have any questions for Mr. Bender? General Medlock?
Jay, do you have any specific recommendations as to changes in the current FOI?
I think one of the things that dovetails with what you've been considering is a mechanism by which ethics complaints will be considered by an independent body. And I think it would be helpful if, in a similar fashion, we could have evaluation of Freedom of Information Act claims made by an independent body. If you file a Freedom of Information Act lawsuit, it because we don't have non-jury court regularly in South Carolina because we don't have the resources. It can be 2 years before the case comes to trial, and that leads to situations like the Berkeley County School District having lawyers perform the evaluation of the superintendent so that the claim of attorney-client privilege could be made to shelter from the public the individual board member evaluations of the superintendent. When the case got to the Supreme Court, ultimately it was reversed, and then that superintendent had gone on to other employment, so the school district said, okay, here are the evaluations. Meaningless because of the passage of time. It's expensive to litigate. The city of North Myrtle Beach had a dashboard videotape of an altercation between a police officer and a woman in a fire station in North Myrtle Beach. The city manager said he knew it was a public record when requested to reveal it to the Sun News. He said, but you're going to have to get a court to tell me to give it up. Well, there were 2 plaintiffs in that case. One plaintiff's lawyer was reimbursed $20,000 for his effort. There was another plaintiff's attorney who didn't do a very good job of keeping time records, and he didn't get nearly that much. And the city paid $20,000 for its own attorney. So we have nearly $50,000 and a delay of 6 to 8 months before a tape that the public official knew was a public record could be revealed. So I think we need a streamlined process, and we need a way to do it independently of litigation, because I think that doesn't work very well given the backlog of cases. And the criminal prosecutions are unavailing these days for 2 reasons. One, the law requires that the violation be willful, and the one case that has been tried had a judge define willful as not only do you have to know you're acting, you have to know that your action is in violation of the law. Now, I didn't try the case, so I can freely say that I didn't think that's what the definition of willful was, but that was what was charged. And now the Supreme Court has issued a rule that criminal prosecutions in magistrates' court cannot be brought by others, can only be brought by the solicitor unless it's an individual. So depending who is trying to enforce the Freedom of Information Act by the criminal provisions in the current law, you have now a solicitor who has to make a decision to prosecute. And since these cases often are against public officials who come from a political environment like the solicitor, it's difficult to persuade a solicitor to bring those cases. So I don't know what the answer is, so I'll be a candidate and suggest what we need is something, and I'd like to work with you to help develop what the something is.
Someone suggested that the administrative law courts might serve in that capacity. What do you think?
Well, I'll give you a story. There was a case pending in the administrative law court, and news organizations made requests for records relating to the case, and the administrative law court refused access to those records. Now, had they been in a court under our judicial department, those records would have been made accessible because of the constitutional guarantee of access. But the then chief judge of the administrative law court thought that those records should not be made public. And a case was initiated, and it went to the South Carolina Supreme Court, and the Chief Justice at one point during the argument was being told about the administrative law court, and she leaned across the bench and she said, "That's not a court. It's part of the executive branch. It's not a court. It calls itself a court." But so I'm unpersuaded that that's the place to have these issues resolved. It might be. Membership of the court changes from time to time.
Jay, do you have any idea the statistics, the number of cases that are brought annually to enforce the act?
Very few. If I had to guess, I'd say there are probably fewer than 20 statewide. There are many more violations of that, but people are dissuaded by having to have an attorney and having to go to court, even though the law provides that a successful party would be reimbursed. News organizations don't have the resources to commit to filing these lawsuits like they did 20 years ago, 30 years ago, and citizens certainly don't. So I'd like to find, and I think, Chairman McMaster, an administrative executive branch type agency would probably be an effective way to do it. My experience with the administrative law court suggests that that's not the one, but I think we could find one.
But your experience with administrative law court is, your criticism of that is based on the openness of the records of that court.
Their own records, do as I do, not as I say, doesn't seem to me to be a very publicly effective way to run an agency.
Well, if this commission decides to recommend that something be established, it might be easier to use something that already is established than creating something out of whole cloth.
Oh, I agree. And I think that with the appropriate understandings and education, that the problem might not exist in the future.
Jay, the examples you used appear to be all instances of failure or refusal to disclose information that presumably should have been public.
That's correct.
Did these also, each or any of them also involve a Freedom of Information request?
Several of them involve litigation. The Anderson County case involved a suit seeking a mandamus. It went to the Supreme Court. The York County Sheriff case involved litigation. The Cherokee County case did not involve Freedom of Information Act litigation, involved other types of litigation with the same parties.
So none of these were brought under a Freedom of Information request?
The York County Sheriff case was. It was reported as Burton versus York County Sheriff. The School District 5 case provoked then Solicitor Dick Harpootlian to consider a criminal prosecution of the board members, but for some reason decided not to. But he had thought at the time that it might be appropriate to initiate criminal prosecution against the board members for their refusal to disclose records about the location of that high school.
Is there a state Freedom of Information Act that you consider more effective than what we have in South Carolina, that you'd point to as an example?
I can't. Each state has an act that provides access to records and meetings, and they all have advantages, they all have disadvantages. I think South Carolina's law is pretty good. The Western Band of Cherokee, the Cherokee Nation in Oklahoma, adopted a Freedom of Information Act, and its model was the South Carolina Freedom of Information Act. So it thought that it was adequate. I think the problem is cultural and resource related. We have a culture that is willing to accept governmental secrecy when it's inappropriate in a democracy. I think the General Assembly explained the Freedom of Information Act very eloquently, and I'll give Co-Chairman Medlock credit for writing this, whether he wrote it or not. It said the General Assembly finds that it is vital in a democratic society that public business be conducted in an open and public manner. And that seems to me to state it pretty effectively. And the Supreme Court of South Carolina said repeatedly that the purpose of the Freedom of Information Act is to prevent secret government activity, and I think that's what you're about, the prevention of secret government activity. The question is, where do we draw the line? How do we enforce it?
Do you have a recommendation about the application of the Freedom of Information Act to the legislature?
Yes. I think that, and in fact, when the discussion came up last year in the House Judiciary Committee over the elimination of the General Assembly's more or less blanket exemption from the Freedom of Information Act, I, at the request of members of that committee, prepared a proposed amendment that would have sheltered communications by constituents or from constituents to members and from members to constituents. But otherwise, the records of members of the General Assembly would be made public, subject to the same exemptions that exist for other public bodies. So I thought when that amendment was raised in the Judiciary Committee that it had the appearance of a poison pill, and I thought that it might have been introduced to derail the proposed changes in the Freedom of Information Act. I'm less certain of that now, having talked to the sponsor of the amendment, but I think that there was a way to work around it. But when you say all members of the General Assembly have an exemption for their working papers and their correspondence, that deprives the public of an opportunity to understand how legislation is formulated. I mean, we can think of horror stories. The change in the budget that allowed video poker suddenly to become legal, it would have been interesting to see correspondence related to that, but it would have been subject to the blanket exemption.
But your proposal back then was that correspondence, which I guess would be emails, written correspondence.
Yes.
Any kind of correspondence broadly construed between the member and a constituent would be exempt.
I would think so, because I expect that there are some sensitive discussions. For example, our first speaker here tonight was having difficulty with a VA claim, and I suspect he's communicated with members of the legislature, or somebody in his situation could, and those would be the kinds of correspondence that it might be appropriate to shelter from public discussion. I mean, I'm sure there are other examples. People write members all the time asking for assistance, as Travis knows and Flynn knows, because he's written those letters too.
Could you see the enforcement falling under the State Ethics Committee?
Well, if we're going to have a state ethics commission that's going to be charged with conduct, investigating and dealing with conduct by all public officials in the state, by members of the House and members of the General Assembly, and hearing Freedom of Information Act claims, there has to be a much more significant commitment of resources to that agency to get it done. I think that agency does an admirable job, but it's really two people down there doing the investigative work and doing the administrative work, and that's just inadequate.
With commitment of resources, could you see it falling under the jurisdiction?
Certainly. You know, and the procedures that have to be established, but that can be done. At one point, I was chairman of the state's Occupational Health and Safety Review Commission. We started from zero and developed our own procedures and went forward and held administrative hearings. And so the process can be dealt with. It just has to have the resources to make it possible. And the Ethics Commission right now doesn't have the resources to do what it's been charged to do under the current law.
Gentleman, a lot of clarification. Are you asking about the enforcement of the Freedom of Information Act by the Ethics Commission?
That's what I understood the question to be.
Well, members, we have somebody here who knows something.
Well, let's get him up here to the microphone.
I got a question, Jay. If all of the enforcement for the Senate, the House, everything goes to the State Ethics Commission, and yet the State Ethics Commission gets funded by the legislature, isn't that an inherent problem? Because in other states where that's true, I think Georgia's an example. As soon as the Ethics Commission started investigating the legislature there, they simply cut off the funding, and there was a horrible crisis, and not surprisingly, the number of investigations in Georgia dropped.
Sure.
And so, I mean, that's a it's just a real fact of life that we've got to deal with.
It is a fact.
Not suggesting that our legislature would do that, but
well, let's look at it this way. Do we commit the resources we need to run a judicial system in South Carolina? The Chief Justice comes to the General Assembly every year and points out what the backlog of cases is, how many more judges we need. the General Assembly is not going to fund the judiciary. It's probably not going to fund an agency that's going to look into its dealings. But you know, how do you rise above that? I think that's where public pressure and peer pressure comes to bear. We wouldn't have had the ethics legislation we have now if it had not been for peer and public pressure following lost trust. It was the fact that so many honest legislators were severely embarrassed by the activities of their colleagues that there was a groundswell of support for ethics reform in the fashion it was. And it, you know, could it have been done more effectively? Certainly. But it was what got done when it got done, and it has worked to some extent. I think that in tough economic times, when the demands on the public purse are for schools, for roads, for public safety, an agency to investigate ethics and an agency to investigate the Freedom of Information Act will always bring up the tail end of the parade.
Someone suggested a multi-year budget for the Ethics Commission or the enhanced investigatory body. I don't know if we've done the research to see if that would be constitutional, but if so, that is, you have a 2-year or 4-year budget that would render that budget less susceptible to immediate cuts, reactionary type cuts. Would that be helpful?
I would think so. I think anything to remove the direct, immediate political pressure from the process would work. Standing here, I was thinking, you know, could you do it? You know, we always hold up the base realignment and closing commission as a way to remove politics from a process that's fraught with politics. Maybe you have an independent commission that establishes a budget. But how do you bind the legislature to enact that budget? I don't know. But there would have to be some legislation that would do that, and the constraint there is one term can't bind other terms, so there's always the opportunity it could be repealed.
This is a radical idea, probably unworkable.
I'm all in favor of that, then let's go for it.
I'll play with the idea of having a constitutional provision encompassing some sort of formula based upon population growth relative to funding, and maybe our constitutional expert would be a person to respond on that.
I think that anything you can do to eliminate the prospect that there will be punitive budgetary action taken in the event of an unfavorable Ethics Commission review of a member of the General Assembly would enhance the public's confidence that the system will work. Right now, the public doesn't have any confidence that the House or Senate can honestly and effectively evaluate the conduct of the members of either body.
General Medlock, there are, I think you've seized on something, because there are a few options operationally in which you could ensure some measure of independence by securing a steady stream of funding for an ethics commission. One way in which that's been done is similar to how we treat the pay of judges at the federal level, which is to ensure, perhaps constitutionally if necessary, that the funding for an ethics commission isn't cut by a particular amount from one year to the next. One way in which you could do that is to say if there were general budget cuts across the board, that the funding to the Ethics Commission can't go below that percentage of cuts that occur across the board. The other is to tie it to another department within the government, say as part of the judicial branch or the judiciary, and to say that the Ethics Commission will receive a certain percentage of funding that's a fixed percentage every year. So say it's 2 or 3% or however much it would be identified as sufficient for it to function. But they would receive a set percentage of the allocation for that particular branch in each budget cycle. But all of those would likely require some form of constitutional change.
Constitutional amendment.
Yes.
What would you think of a formula based upon population growth?
I think your idea is better than mine.
I doubt it. I doubt it. But you raised some interesting possibilities.
But that general approach is one that has been used, and it does insulate the commission to some extent from political pressure based on the apportion, the funding process.
Very good, very good. Some good ideas there.
And we would hope that the public pressure would be a counterweight to the political pressure. The most widespread reforms of the Freedom of Information Act occurred when the public became incensed at the excesses of a president of the University of South Carolina and the Carolina Research and Development Foundation. And the General Assembly was only too happy to respond to that public pressure by enacting several meaningful reforms. How do we get another situation like that? I don't know. I sense that public pressure is building for something to happen to restore confidence by the public in those who govern us when it comes to their conduct, whether we call it ethical or legal. And this commission is evidence that the political forces recognize that. So we just have to push forward.
It would be nice to get out ahead of the next disaster and avoid it, wouldn't it?
Well, yeah, that's true. They're saying the same thing in New York and New Jersey right now. How are we going to get out in front of the next storm? Forecasting is always a challenge. You know, since I'm in the presence of two generals, what's the complaint about generals? They're always fighting the last war. You know, so you have to be visionary here and figure out where the next battle's going to come.
Any more questions for Mr. Bender?
Thanks for your many years of public service.
Well, thank you. You were my inspiration, and I appreciate the opportunity to be here.
You realize we'll be calling on you up until January the 28th.
Sure.
We need help.
Well, I'm happy to help any way I can.
We thank you.
Thank you.
The gentleman in the back, if you'd come forward and state your name, please, and welcome.
Greetings. My name is Craig Adams, political advisor, conservative activist. First of all, Ms. McWilliams, my personal opinion, I think this legislature would. Tomorrow morning there is a House Caucus Committee dealing with ethics at 1 p.m. You might want to come and bring that up tomorrow. That would be a good time to bring up the revenue thing. You know, the cornerstone of a democracy or a republic as we have is justice. It's got to be. Justice sometimes is subjective, just like ethics. We're sitting here trying to find an avenue, of course, to deal with unethical and illegal issues in the public sector. But we should also make sure we put something in there that deal with the innocent bodies. There's been numerous cases in the last few years where people have been alleged to have done something, has not. And I think there needs to be not only some type of hotline that will allow people to call in so that they don't have to deal with people face to face. There are a lot of people will call in a hotline, and where there's smoke, there's fire. But there also needs to be some type of mechanism to protect the innocent, because I've probably worked on over 300 campaigns in over 30 years, probably 50 in the state, and I have seen people who have been accused, alleged, there's been insinuated that they've done things they didn't do. Transparency needs to be the most important part. I've been pushing for this for a long time with the governor, with the attorney general, and with the House, and I think it looks like now it's starting to come to fruition. Mr. McMaster, you know, I've met with you several times when you ran for governor, and this is one of the key things that you wanted for this state, because you understand that the economy, when other people, we're going to have to compete for industry. We're going to have to compete for the brightest minds. We have to have a fair playing field. And one of the things that discourages me more, besides some empty seats, after sending out 38,000 emails statewide, I get none. because they're not taking it serious. I believe, knowing a couple of you people, I believe you're going to take it serious. We need to make it serious, because I've been behind so many people that run for public office, most time behind the scenes. But it's amazing how many of them tell me they don't run for office because it's not fair. That's a word I don't like to hear. Because all these people that have been accused of things, under investigation, whatever, I don't want to name any names, but there were people that ran against them. And they knew these people were bad. They knew they were dirty. They borrowed money. They walked the streets. They went away from their families. They made promises that they were never allowed to be challenged to keep. We must make this fair for the people that are not in the limelight, that are not in public office, for the people who aspire, and for the people who are willing to say, now that I have a fair playing field, I want to enter in the public arena. I want to represent my grandma, sick people, school children, police officers. As far as the funding, you transparent this thing, and you make it open, you'll get your funding. There's enough people out here, when you show that you're doing it, and you're doing the right thing, and that you're making an impact, they're not going to shut you down. That I can be assured of. Really appreciate this man's knowledge. I hope that y'all do in the future, and that you're not just speaking that you take people like this and you bring them in and use them for what that they know, because the vast pool of knowledge is critical to this type of thing. I'm not going to spend as much time on it as anything, but sometimes we talk about corruption. We don't understand that there's corruption that you see. There's corruption that's illegal. But there's a whole lot of ethical problems out there that are not necessarily illegal. I think in some cases that needs to be defined. Because we have school boards, we have county councils, we have a lot of things, not just on a local level, but there's a lot of agencies that raise taxes without the public's consent. That's going on all over the place right now. We're being taxed to death. My own county, Lexington, is passing taxes left and right. The school board, the council, and I don't care what anybody thinks. Biggest complaint I had against the Amazon.com thing was that they gave away land, they made deals, they shook hands, they kissed, they made the deal, and then they decided it was important for us to know about it. I wasn't against the deal as much as I was the method in which that was arrived. I don't have a lot more to say except for the fact that I hope that y'all take this serious, and we need to find some way of getting the public more involved in this, because in my personal opinion, this is sad. There's more media people here than there are concerned citizens. Y'all have to figure out why. You know what I'm hearing? They think it's all a stage. And knowing some of you people, I'm not going to say who I know and who I don't know, but I will tell you this. I don't believe that. I have been meeting with everybody and their brother trying to get this going and doing it because it's critical to the economy, to the education, to the security, and to the future of our children. You know, I have a lot of I have grandchildren now that are going to have to look down the road, decide whether they want to stay in the state or not. We need to keep the brightest minds. They need to know that they're being represented by ethical and moral people. And if we draw the line at ethics only in public roles and not in the person themselves and the way they conduct themselves as citizens, then I think we're cheating ourselves, and this is going to be a fruitless endeavor. Thank you for your time.
Thank you. Is there anyone else who'd like to make a statement or ask a question? Ms. Timberlake?
Good evening. I had to choose between going to the PSC hearing tonight that the earlier gentleman was looking for, but I came here because I appreciate so much the job that you have undertaken. I'm Ann Timberlake. I'm Executive Director of Conservation Voters. I really didn't come with a prepared statement. I want to make a few observations. And I want to make a particular point. Last summer, I think you will recall this was a very publicized discovery. There was a representative who'd he was paid by an association. It had never been divulged. It was an association that was the lobbyist principal, but because of the sort of the intricacies of the law, it was deemed that he'd not broken the law. But what I want to say is it made me want, as a defender of the environment, it made me want to put an ad in the Free Times saying, for hire, to represent the environment, legislators apply. Okay? The idea that you know, and I'm not even opposed to someone being able to be hired for consulting, but we need to know we need a level playing field, and that needs to be divulged. And so that's the disclosure issue, I think, is really very important in finding a way to make that fair and reasonable, whether there are some exemptions under a certain level. I think maybe there's a middle ground, but that is very important to us as from the environmental community. I don't pretend to be an expert on how to protect the public. I'm much more comfortable talking about how to protect our clean air and water. But I think there's a relationship there. And I think when Jay said that it's not just ethics reform, this is maybe legal reform, it's writing these regulations so that they are very clear and easily understood and enforceable. The other comment that I was thinking of when we're talking about public pressure, and the ultimate public pressure is the ballot box. But we are not going to that's not going to be able to be as reliable a check when we don't have competition. And I don't think this is maybe on your plate, but South Carolina, many states have a more bipartisan and independent redistricting. You know, ours is all done through the legislature. And the way, you know, we had a House member who is paying a fine for not paying taxes. It's been known. He had no opposition. We have districts that don't invite competition. And that's a little separate from what you're doing, except that the ultimate check is really to have transparency and let the public then cast their vote. And I will just say that the other point, and I speak more as a layman here, but the idea of investigation and enforcement, and I think making complaints, ethics complaints, you know, public, as long as you have some exemption, I guess, for frivolous. But the more public disclosure, I think the more, again, the more we can rely on the public to have a check. And as to who, I do think as a state where we sometimes get into muddy waters is we don't have enough separation of powers. So I can't speak with any authority about administrative law courts, but that would concern me to look there. And I also almost like keeping enforcement within each branch. You know, are we talking about if we were to give this to ethics, would they also be doing the judicial branch? They police their own. And so I think there's some argument to be made that there needs to be an independent investigative authority. And then maybe there's some mechanism for the ultimate enforcement going back within the branch. Just because it's when we get an unbalance of the separation of powers that I think we get into trouble. So those are just some observations. We may want to make more, you know, more of an official statement at a later hearing. But I want to thank you for what you're doing. Do you have any questions?
You touched on something that we've received some comments on, and that is that legislators, the question of whether they should be required to disclose income from, certainly from government bodies, that is, work they do with a government agency is required to be disclosed now for every public official, the precise amount, the source, and everything. Do you have any insight or thoughts about disclosure of sources or amounts of income from other sources?
Well, absolutely sources. I think there's more leeway when you're talking about the amounts. And I mean, I know there's a whole question about lawyer-client, relationships. And what we're really talking about is the idea that a legislator could be working for an organization that employs a lobbyist, but because they're consulting, they weren't reporting that. So I think that's a loophole.
What you're suggesting is that if a legislator is working for a company which has a lobbyist, that they should disclose that relationship,
I mean, that's
the
the
source
first
of that
step.
income.
Yeah, I think that's the first step. And again, I know there are some exemptions. There was, I'm not, I read that article more as a layman. I'm not a lawyer. I'm not an expert in this. But some of this is common sense, and when it flies in the face of what you would expect, again, I don't really mind if they are hired. We just want to know. We just want to know. We think that makes for, that's better for the public.
Would you endorse full disclosure of income by nature and source?
I think maybe not. I don't necessarily feel the amount so much.
Just
But
the nature and source.
yeah, I'm inclined to. Yes.
What does nature mean?
Yeah.
I read that. What's that mean?
What does that mean? That's not the nature I'm talking about when I'm protecting clean water and clean air.
And is the expert on nature, then you can direct that question at her. And if it weren't for you, there wouldn't be any fish in the rivers in the state.
Well,
You've done a magnificent job.
we like being part of the process. I still am naive enough to believe that the public will be a check. I still have to believe that. So, but we have to give them the information. Anyway,
Do
thank
any
you.
commission members have a question for Ms. Timberlake? Yes, sir. Mr. Rogers?
Ms. Timberlake, I like your idea of the independent investigative force, but if you leave the actual decision-making to the body itself, are they going to vote against maybe a powerful speaker or someone like that? Would that be independent enough for you?
I really don't know. But again, going back, if it's public and the public cares, then that the ballot box, that's kind of, that's their opportunity to register their discontent. I mean, I don't know. I'm just not certain that I can't remember who appoints the Ethics Commission. But, if that's appointed by the executive branch, and then that entity is enforcing on the legislative branch, I would be cautious of this separation of powers.
But the Ethics Commission in the legislature is appointed by the Speaker of the House.
And I'm not defending, I really don't want to appear to be defending that. Absolutely, I think it's not working. And the investigation definitely, I think, should be. They're not staffed to do a proper investigation. I think, and maybe there's some level, but I don't know. It's a concern. I don't have the answer to that.
Well, that brought up a question that I know that there's been some comment about, and that is the constitutionality of some entity other than the House or the Senate being the judge of their own members. And I know Professor Dean Robert Wilcox testified at one of the caucus meetings that it would be unconstitutional for anything but that the member, the body made up of members from that body to impose discipline. Professor Simpkins, was I reading that right?
Yes, sir, you were. General McMaster, I tend to still believe that that's an open question, and that there may be avenues to achieve the goal of creating an ethics commission with broad jurisdiction, which would include members of the legislature, without changing the Constitution. It's instructive to note that there were two bills that were introduced in the last legislative session, one in the House and one in the Senate, each intending to bring under the jurisdiction of the State Ethics Commission members of the legislature. And there was no perceived constitutional failure in either of those bills. It's also worth noting that of there are 39 state ethics commissions that exist around the country. Some states like ethics commissions so much that they have more than one. So of those 39 state ethics commissions, they exist in 35 states. Of the 35 states with state ethics commissions, 31 of those state ethics commissions have jurisdiction over members of the legislature. So it's actually a majority rule, if you look across the country, that members of the legislature fall under the jurisdiction of those
Do you
commissions.
recall how they are selected or
Yeah,
appointed?
that's what I would like to know.
How the commissions are appointed? They tend to be appointed by input from at least two, if not all three, branches of government. So that everyone has a stake. And the removal procedures are also interesting. I've looked at that a little bit. This is still ongoing research. But the removal procedures are interesting because they often involve more than one branch of government, so that there can't be political removals. One example is to have the governor suggest removal and then to have the legislature ratify that suggestion, essentially.
Would you see any legal impediment to the legislature establishing by statute a state commission, ethics commission, with the limited authority to protect the balances, and at the same time in enacting legislation to place on the ballot a constitutional amendment to do the same thing, adding the right of the state commission to have total jurisdiction over all entities in all respects, investigative, recommendations, and enforcement?
Based on what I've seen in my research thus far, I wouldn't see a problem with that. One of the concerns that's been raised by members of the legislature is that the two houses in the legislature have the ability to make their own rules, and they can discipline their own members. But it's instructive to look at that constitutional language. In the state constitution, it says that each house of the legislative branch may punish its members for disorderly behavior. And I think you can make a clear reading of that in plain language and make a very strong argument that doesn't apply to the kind of behavior that we're considering when we're talking about violation of ethics rules. It's not part of the core legislative function.
You're talking about throwing the drunks out of the...
Exactly. No caning on the floor, just as an example.
You know, with all due respect, some people suggest we need a new constitutional convention, but I'm not making that suggestion.
Well, your question a moment ago, you asked about the composition and the process for establishing for the Ethics Commission. The South Carolina Ethics Commission has 9 members, one each from each of the 6 congressional districts and 3 at large, appointed by the governor for a 5-year term. And I don't know if that's with advice and consent of the Senate or not. The House Legislative Ethics Committee has 6 members elected by the House, and their terms are coterminous with their term of office, which of course is everybody's up at the same time every 2 years. And then in the Senate Legislative Ethics Committee, you have 10 members elected by the Senate, and the terms are coterminous with their terms of office also. That's where they come from.
Thank you.
Thank you very much.
Give your husband out of the door.
Yes, sir. State your name, please, sir, and have the microphone.
I'll be heard, but not seen, apparently. Most of the TV stations are gone. My name's Larry Carter Center. I live at 20 West Pawnee Drive in Charleston. The zip code's 29407.
I didn't catch your last name, please.
Okay, I have 2 last names. Carter, C-A-R-T-E-R. Center, C-E-N-T-E-R.
Okay, thank you.
I come tonight with a big mouthful, but first I just want to show this penny. I'm sure some of you, if not most of you, know that 5 states in America have penny a day per voter per election, so that penny a day per voter per year less than $4 a year will publicly fund elections. It's pretty obvious we're not stopping the bribery. The bribery is rampant, it's epidemic, and my opponent in the last election, Bobby Harrell, just is stealing money from corporations at whim and at will. I'm just shocked by it, how nothing has been done about this man. He's got a $500,000 airplane, and he just thinks that he can bill his campaign $900 to come to work as a legislator. I think most of the legislatures live on the 44.5 cents mileage one way beginning of the week and 44.5 cents one way at the end of the week, go back home. But Bobby needs his $900 every trip. This is shocking. It's obscene to me. And I've lived in this state over 7 years, and I'm still devastated that the Chamber of Commerce, the anti-union forces in the state, are responsible for killing 9 firefighters just a mile from my house. We need to have union protection, union safety equipment, union safety work rules. And why it seems to be open season on unions, and the Chamber of Commerce can just throw money after money after money to both sides of the aisle, to both the Democrats and the Republicans. Not each and all of them, but definitely throwing it on both sides. So instead of one by one picking off these criminal violators of any common sense standard of personal gain from campaigning funds, maybe we can shame them by having publicly funded elections so that some honest candidates can live on a penny per voter per year per day. And then we continue and strengthen reporting requirements. So I hope this committee will recommend that we have publicly funded elections, make South Carolina the 6th state in the nation that has publicly funded elections. And I hope this committee will define what legislative travel is. I think it's already defined in the statute. It's 44.5 cents a mile. It's not $900 in your personal airplane. And I'm just shocked by it. I can't tell you how much I'm ashamed of the elected officials in this state that have just one thing after another. Now, I'd like to talk about our governor. I think that anybody that wants to hurt the business in this state by helping the business in another state is again, shocking. And when anyone says, oh, we can compete, that seems to me like the green light for we're throwing more money into the pockets of politicians and allowing toxic sludge dug out of the Savannah Highway and dumped onto Jasper County, out of the Savannah River. So I will not be quiet about it. I'm going to keep on talking. I know you have a couple more meetings coming up. I hope you'll come to Charleston. It's a dangerous, wet, very poor visibility trip here. We can fix this problem. We can fix this problem. And publicly funded elections is a big, giant step towards fixing this problem, because so many of them have done it. And just, 14 years ago, they put 17 members of the legislature in prison. I mean, do we need the FBI to come to Charleston and come to South Carolina again to solve this problem? And it's not the only state. You know, we've got Governor Blagojevich in federal prison up from the Illinois governor's chair. And it just seems that just a handful of prosecutions is not stopping all the rest of the candidates from taking all these millions and millions of dollars from corporations and smothering the voters. So I spent about 50 cents per voter in my race, and Bobby spent about $30 per voter in his race. And I don't know how much Mr. Steinberger spent, but it was demoralizing, to say the least, that I'm not even a resident of Lexington County, and I was kicked off the ballot of the Democratic Party. I've been a Democrat since 1974, and it's just absolutely shocking to me that any judge would just, out of the blue, say, let's throw them all off the ballot. I mean, lawyers were tricked into thinking they didn't have to file that piece of paper because you go to the website, you declare you're a candidate, and it doesn't say, oh, by the way, you still got to go file that piece of paper. It doesn't say that. So luckily the Green Party stuck by me and kept me on the ballot. But it hurts me deeply that I wasn't allowed to work the friends that I have in my party that I've been in. And it is a good thing that you can belong to many parties in South Carolina, because we have a Working Families Party, and we have a United Citizens Party, and we have some good reforming people who want to clean up the government in our state here. So I'll be happy to answer any of your questions, but I came here because it's not going to get any better until we have a real alternative to this massive flood of money from corporations and very, very wealthy people. And I just want to say one more thing. It was 3 or 4 years ago, on the next last day, if not the last day of the legislature, that they passed a law, and I can only call it the Church Land Speculators Bill. Any nonprofit can just go out and buy a piece of land to speculate for future sale, tax-free. And any nonprofit can already acquire land for their own nonprofit purposes and not pay taxes. So why do they have to pass a new law? Because they can go speculate on land. A cash-rich corporation now can do that in all 46 counties. I find this, what do we got to do? Interrogate, tap their phones, do what it takes to catch these people bribing our legislators, say, hey, that's what I want because I'm going to get rich doing it. I mean, I'm here begging you folks to have a conscience and try to solve this problem.
Well, we appreciate your time and interest, and thank you for coming up from Charleston in the fog.
Could I ask you one question? How do you convince the public how do you convince the general public that public financing of campaigns is the efficient and best way to go?
Well,
because people do not like the idea. It's a very interesting idea to me, but people do not like the idea of having to pay for politicians to run TV ads on themselves.
Well, we have it for the presidential campaigns, and only the current president has declined to live within publicly financed limits. And again, as I said, they're very similar in the 5 states that we have it. It's the way I understand it works, you get a modest number of people given $100 each. It shows that you are someone who really, people think they want you on the ballot. And it doesn't discriminate by party, so it could be an independent, it could be a third party, it could be a Democrat or Republican. Once you get that initial amount of money and a modest number of petition signers, be it 100 or 1,000 people, you then are allowed to have a preset amount of money that you can run your campaign with, whether it's $15 or $30 or $50,000, whatever it might be. And it's usually based on a formula of per voter actual expenditure for that office. And of course, it usually doubles the publicly funded candidates if one of the candidates running in that office race exceeds those limits so that they can compete. And that's how, as I understand it, works. And if folks think that's not a good thing, I think what we got is even worse. And we've got to shame the people who are taking all these millions of dollars from the corporations and the very, very wealthy. We just can't allow our government to be for sale anymore. And if it's a cost of doing business, it costs money to communicate. I mean, I spent $500 on robodials twice, 11,000 phone numbers. You know, we spent about $2,000. And of course, we would have asked for more and spent more if we had not been destroyed out of our fusion campaign on 3 parties. If I would have had that modest amount of money, we would have had you know, a couple nice students from the College of Charleston working, making phone calls, doing the work of running a nice campaign, and we would have given it a good shot. But it's just, it costs money to do this stuff. And if you don't have it in an above board way, it's under the table. It's gifts to your staff. It's flights in an airplane to a Bulldogs game, whatever it might be. I understand your question, and I've been on the radio fighting for this, arguing for this, and I do agree with you that a lot of people don't like the idea of funding politics out of the taxpayer dollar. But if it was a checkoff system where you can check off, yes, I want $1, yes, I want $3, whatever it might be, to go to funding my elections in my state, I think a lot of people would choose that option instead of the system that we've got now, which is just absolutely intolerable, just intolerable.
I think it was the Reagan-Carter campaign that was publicly financed.
Say again?
One of the Reagan campaigns was publicly financed.
Ever since before, all of the presidents have been publicly financed. And only President Obama, as candidate in 2008 and in this current general election cycle. Now, they all stayed within the limits during the primary cycle, but yeah, we've had public financing at the federal level. Nixon signed the law, and Ford and Carter and Reagan and Bush, all of them have lived in it, and only Obama has not lived within those limits. And of course, we also have the other problem of super PACs. Now, Bobby's got his super PAC, and these just throw money like crazy. I mean, they're still running until April and May on radio stations in Charleston, running ads for the last January. They bought so much airtime they couldn't possibly run it all during the day because these super PACs are just throwing thousands and thousands of dollars into the radio station saying, here, I want these ads run all the time. So this kind of money is only creating tremendous apathy and disgust. And I think there was about 25 comments on the notice in the state paper about this meeting here tonight. And with maybe 3 exceptions, encouraging you folks to do your job, most of them says you were all crooks to begin with, and they didn't expect you would do anything good. So I'm here to beg you, please, do something that's going to change this system.
Thank you very much, Mr. Carter, Senator. I did have a note here a moment ago when I was describing the selection process. The State Ethics Commission, which has the 9 members, 1 each from the 6 congressional districts, and 3 at large appointed by the governor for 5-year terms, they are confirmed by the advice and the consent of the General Assembly, not just one body or the other, but by both, for the information of the group. Anyone else? Yes, ma'am. Come forward. Your name, please.
Come listen to y'all, but I have a story.
Tell us your name, please, ma'am.
Susan Swanson, North Augusta, 1130 Audubon Road, North Augusta. Well, I've experienced kind of the intimidation factor of our state firsthand, and that's why I'm here. I mean, I've been to Russia on mission trips. I've seen what communism does. I love America. I have run for office 4 times. But what I've seen in the process of running is kind of frightening. It's not good. It's not healthy. It's not proper. When I ran in 2004, I ran in 96 against a lead senator. And I ran in 2004. Within an hour and a half after putting my name in Aiken, I got a call from a senator from the floor. He said, I'm on the floor. He was a friend of this senator's telling me I should get out of the race. Now, I should have reported that. That's my probably not wanting to stir up too much trouble. But I think that's happened more than we know. I'm afraid it has. And then I got more phone calls for several weeks from people from other senators. I stayed in it for 6 weeks, and basically just because of my work and just dealing with all that. But that kind of thing I know is not legal. It's not right. I know it's not proper. I don't know who polices that. I don't know who watches that. And 2 years ago, I ran against a House member who's head of the Ethics Committee. And I kept getting letters I got 5 or 6 letters to pay $100 to the Ethics Committee because I didn't file online. Well, the party didn't know, Republican Party didn't know you had to file your disclosure online before you, within a certain time period. The local party didn't know, the state party didn't know, Republican Party. So I'm curious, because he is a Republican, how he didn't tell anybody the new law had been passed. Well, really, the law hadn't been passed. The law had been passed, but it wasn't supposed to be enacted until 2012. That's what I understand now. So I was intimidated by letters coming to me and phone calls coming to me. So this is a problem. You can't have people running for office that really have good ideas. I mean, I've spent lots of my own money. My husband keeps saying, why are we spending all this money? Well, I think freedom should be free. And I think we need to keep our country free. And if we don't keep plugging away at the establishment 30-year, 33-year people, we're not going to keep America free. We only keep our state free, our county free, by being active. And I'm very active with a lot of things. And so people know my name. People understand my integrity. I'm not trying to badmouth anybody, but I think it needs to be looked into and how people use their office to keep their office. That's very dangerous. If you can use your office to intimidate a person running against you, that's very dangerous. So I hope you will investigate these kind of things. I'll be back if you want to talk to me. I'm just concerned about how things are being handled from the inside out. Maybe that was right, that those letters could have come to me. Maybe it was all proper. I don't know. But what I'm concerned about is it was just strange. So, okay.
Thank you, Ms. Swanson. Any questions for Ms. Swanson from the?
Question, were the letters that you received, were the senders identified, or were they all anonymous?
Ethics Commission.
I mean, the letters that urged you to drop out of the race.
No, ma'am. This is two different stories. The letters were that I didn't file online and need to pay $100 to the Ethics Committee. My point with the Ethics Committee is you didn't inform anybody in the parties to inform me. When I went to sign up, my Republican Party chair, Dennis Saylor, had no clue about the law. If the law was passed and it was supposed to be enacted, he should inform, because he's our delegation leader, inform the party, inform the state party. I call the state party, do you know this law? No. Local party, don't. No, nobody knows any laws. Now, if you can pass a law and never tell anybody, that's strange. That's really strange, because that means you have the inside scoop and nobody knows. I saw this 2 years ago, and I warned the party about this. But this stuff is not the way you handle business. You cannot play that kind of game. That's an inside deal to me. So my husband said, you do not write a $100 check at all. For the reason something was goofy. Something was very, very goofy. I have all my letters.
Mr. Beerbell?
Were you one of the candidates who was removed from the ballot?
No, ma'am, that
because
was 2 years ago. I ran in 2010.
This was prior
Yes,
to
I
that.
saw the same thing that was happening this time, but I got it the first time 2 years ago. I got the letters 2 years ago.
Are you advocating any specific changes in election law or election proceedings? I mean, do you have something specific in mind?
To me, if you're a legislator and you pass a law that affects elections, you should notify the election commission of every county. You should know. And I ask, have you know? Oh no, we don't have time. That's what I was told by this office of the ethics committee. We don't have time to notify them.
Which office is that?
Well, it's Roland Smith's office. Okay, they don't have time to tell everybody the laws. Well, that's interesting. You don't have time. You don't have time to email them, send them a letter, fax them. I run a nonprofit, and it's hard to raise money, believe me. So the idea they couldn't inform the election commission, they couldn't inform the parties, they couldn't inform the Democratic Party, that's strange. That's when I was told 2 years ago, we don't have time. So it's just weird. I mean, if it wasn't so scary, it's weird. But, I mean, I stayed in the race, but, you know, and I'll run again. Because if we don't keep running, we will not clean it up.
Any more questions for the lady? Thank you, Ms. Swanson.
Thank you.
Appreciate you coming here
I
to
didn't
be
come
with
to
us.
speak.
Well,
By God's design.
I'm glad we inspired you, or somebody did. Anyone else with any questions or comments or anything they'd like to say? Mr. Bender, did anything come to mind while you listened to the others? Because we'd love to hear from you.
I appreciate your service and your patience.
Thank you. Any comments or questions by the members of the commission? Well, there being none, we thank everyone.
Just remind everybody of their next meeting. You do. Okay. I just want to remind everybody, commission members, of our next meeting, Monday, December 10th. Same place, same time. And then for members of the public, we'll continue to send out meeting notices if subcommittees are meeting. And of course, the public is welcome to attend the meeting of the subcommittees. And then on December 11th, as General Master said, we'll be taking testimony from organizations. If there's an organization that people that you know of that would like to present to the commission, I invite you to send that information to me or to General Master or General Medlock so that we can invite that organization to come and present.
How does anybody send it to you? Tell them how to do it.
The best way, my phone number has been put out in the public domain, my office number.
We'll do it one more time.
We freely done.
My telephone number is...
This is open government. Go ahead.
803-255-9586. And I answer the phone. Thank you for that,
And of course, your home number.
We're going to leave it at that number, my office number. And I would also say for any members of the media that would like to talk to commission members, I know General Master and General Medlock will be here after the meeting to talk with any members of the media.
General Medlock, may we adjourn? Have you
It's fine with me, Mr. Co-Chair.
Then we stand adjourned till the next meeting, and thank you very much.